Well, the weather is getting warmer, which has a lot of us outdoors a lot more often. And that may be in your backyard, having some fun on the trampoline or in the pool, or maybe you have a zip line in your backyard like I do. Well, Tom Sinas from Sinas James Law Firm joins us this morning to talk about a case that went all the way to the Michigan Supreme Court involving a zip line. Yeah, if injuries happen in your backyard doing fun stuff, what does the law say about that? Tom, good morning. How are you?
I'm good, Todd. Good morning.
All right. So how did a case involving a zip line on a backyard end up in the Michigan Supreme Court?
You wouldn't think it'd get all that way, because that means a lot of people had to wrestle with a lot of different legal issues. The case started relatively simple with a bit of fun in someone's backyard on a zip line that ended, unfortunately, with somebody being injured. The reason it got all the way to the Michigan Supreme Court is because of a little known statute called the Recreational Land Use Act. Recreational Land Use Act. And the concept of this statute is that it was passed some time ago with the idea of promoting recreational activity on private land. And what it does is it sets forth a couple of concepts that are different from what you would normally expect, that determine whether or not and how some landowner might be liable if someone is injured on their land while performing a particular recreational activity.
Okay, Tom, I'm going to jump in real quick, because you're stressing private property here, because someone might hear this Recreational Land Use Act. Sounds like something that you would hear for a park or for some public use space. But this is specifically for individuals in their backyards.
It is. The statute specifically contemplates a situation where someone else is on another person's land and they're not paying for it, right? They're over on someone else's land. They've been invited to be there. And on that land, they then engage in certain recreational activities. The statute lists a number of them specifically, like fishing, hunting, camping, hiking, sightseeing, motorcycling. But then it has another phrase that says, or any other outdoor recreational use. And if someone is injured on someone else's land doing one of those things and they haven't paid to be on the land, then the landowner is not responsible for an injury unless it can be shown that there was what we call gross negligence or willful and wanton misconduct. That's a very high standard. And so the issue in this case was whether or not ziplining fell into that general category of other outdoor recreational use. Because if it did, then the standard for liability was very high. If it didn't, then the standard of liability was what you would normally expect, what we call ordinary negligence or carelessness. And ultimately, the court found in this case that ziplining was not one of those other outdoor recreational uses. It didn't fall into that catchphrase. And the reason was because the court said in order to fall into those catchphrase, you have to show two things. Number one, you have to show that the activity engaged in couldn't be done indoors. Okay, well, that's true for ziplining. But number two, you have to show that the activity requires nothing more than access to the land. And here, the court said, well, ziplining requires more than just accessing land. It, of course, requires installing zipline equipment on the land itself in order to have a ziplining course. And so for that reason, the court said ziplining isn't in that general category of the statute. And so therefore, the landowner can be liable if it can be shown that the landowner failed to exercise that ordinary negligence standard as opposed to that higher gross negligence standard. So that's how we meandered all the way to the Michigan Supreme Court over a simple zip lining injury.
Most people watching probably don't have a zip line in their backyard, but many people may have trampolines. I mean, those are very common. Pools are pretty common too. I mean, a lot of these activities where injuries could happen. Do you have any practical tips? Because that was pretty technical. That was a deep dive into that Michigan Supreme Court case. What about maybe some practical tips for homeowners that may not have a zip line but have other stuff?
Great question, because you're right. It is technical and it's complicated, and you don't want to have to meander through all this stuff in order to figure out what you need to do practically. Practically, the best thing that you can do is to make sure you're honest with your homeowner's insurance. And that if you add things to your house, like a trampoline, like I did, for example, if you add things to your house, that you tell your homeowner's insurance company that you have those things on your property. Because a trampoline is a good example of certain homeowners' policies may exclude coverage for injuries on trampolines. Others may not. And each of these different type of things that we add to our house, maybe a zip line, for example, our insurance may exclude coverage for injuries on those things. So if you've added something to your backyard to have some fun, make sure you contact your agent, let them know, figure out whether it's covered by your policy. If it's not, you may need to purchase a little additional coverage to make sure that you're protected so that you don't have to worry about all this technical legal mumbo jumbo that we talked about a couple of minutes ago.
Yeah, we would definitely want to avoid that. So be upfront and honest with your homeowner's insurance company. Let them know what's in that backyard. And of course, if the unthinkable happens and someone is injured on that zip line or that trampoline or whatever you got going on in that backyard, where can they get a hold of you, Tom?
They can find us online at www.sinasdramus.com or give us a call at 616-301-3333 or shoot us an email at info@sinasdramus.com.